Good afternoon, everyone. I'd like to welcome you to today's webinar on EEOC guidance update for the employer mandated vaccination. My name is Kathy Purdy. I'm the marketing manager at Bond. Just two quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of your screen, and today's presenters will do their best to answer those as time allows. And if you take a moment to complete the brief survey once today's webinar has concluded, we would appreciate that. So to start today's program, I'm going to hand it to Adam.
Kathy, thank you so much. And thank you to everybody who has taken some time on this Friday afternoon to listen to us talk about vaccination requirements in the workplace. On Wednesday, the EEOC came out with some guidance that started to answer a lot of the questions that businesses and employers had about whether or not they could mandate the COVID-19 vaccination. It was good timing from the EEOC, obviously, because we now have 2 vaccines that have been granted emergency use authorization by the FDA. And some employers, particularly in the healthcare industry, are beginning the vaccination process already. So a lot of businesses are taking a hard look at this question right now, and hopefully over the next half an hour, we can guide you through some of the new information that the EEOC has provided. Our plan is to first give you a brief look at the historical context of vaccination requirements. I know that we've spoken a lot on this topic in past webinars, both in our regular Tuesday webinar, as well as in some standalone pop-up webinars. So we're not going to focus on that too much. We are going to spend the majority of our time today talking about what the EEOC said and what it means for you as employers. And then we're going to close with some practical suggestions that may help you as you're considering whether or not to mandate a vaccine. So with that, I'm going to turn it over to Erin Torsello. Erin is a partner in our Buffalo office who focuses on labor and employment. And Erin, please take it away.
Thank you, Adam. Thank you, everyone, for joining us today. I echo Adam's sentiments. As Adam mentioned, we had a pretty in-depth discussion during our Tuesday webinar last week about the historical context of the mandatory vaccine policies. Our partner, Jess Moeller, did a fantastic job going through some historical background on that. And for a more in-depth discussion on that, I would encourage you to check out our website and go back to that Tuesday webinar and listen to that. But for right now, we thought it would be helpful for purposes of setting up the discussion on what the EEOC guidance has said to just give a very quick summary of what Jess talked about a lot more in depth last week. So historically, the context within which the mandatory vaccine policies have come into play has really been around mandatory flu policies within the healthcare industry. Generally, and specifically within New York, those mandatory flu vaccine policies have been upheld so long as they provide medical and religious exemptions, which Adam will talk about much more in depth a little bit later on in this presentation. We did have some new information coming out of a superior court in California. So as Jess talked a lot about in her presentation, the case law that has come out so far really was around the flu vaccine and really within the healthcare context. This case out of the superior court in California dealt with the plaintiff's request for a preliminary injunction to stop the enforcement of a policy mandating a flu vaccine. Again, it's the flu vaccine, not the COVID-19 vaccine, but it applied to students, faculty, and staff who work or attend school physically within any campus on the regents of the University of California. Very similar to the New York SUNY system. This is California's SUNY system. So the court declined to issue an injunction, which was sought by faculty members and certain students who attend school or who work within the University of California collegiate system. And the court found that due to the ongoing pandemic, that the flu vaccine policy mandating students and faculty and staff who attend either work or school physically on campus could be mandated to get the vaccine from the 2020 to 2021 flu season. So while it wasn't a finding on the merits, and I don't want to get too technical into that, the court will allow enforcement at this point of that policy on students, faculty, and staff, which gives us some insight as to how courts may start to go with the COVID-19 vaccine. But again, the importance of this is that it's outside of the healthcare context. So it gives us some indication that perhaps courts will allow mandatory vaccination outside of the healthcare context. Okay, Kathy, next slide, please. The EEOC guidance, which came out on Wednesday, also gives us some further indication that mandatory flu policies may be allowed. So while the EEOC guidance did not answer directly the question, can an employer mandate the COVID-19 vaccine, it implied that an employer can do so. When you read the FAQs and their answers to the FAQs, it often uses the verbiage, if an employer does mandate a COVID-19 vaccine, and then goes on to answer the question. So it implies that employers have the ability to mandate vaccinations. But again, as we've seen historically, the EEOC has allowed this in the medical context, in the healthcare context. We don't have an answer as to whether or not they will provide some limitation outside of the healthcare context, but we don't have that indication as of yet. Next slide, Kathy.
Erin, thank you. And I think that Erin did a nice job of summing up the historical context there. This is really the first question on everyone's mind. Can employers mandate the vaccine? And I think that, as we saw, and we're going to see in the slides that follow, the EEOC guidance, while it does not explicitly come out and say, you as an employer can mandate the COVID vaccine, what it does say is, what it does do is answer questions that are specifically directed at if you're going to mandate the vaccine. So the assumption is, and the implication is, that you as an employer can do it under certain circumstances. Now, one thing I want to point out, and one caveat, the guidance references the EAU authorization. This is the FDA's emergency use authorization process. And the guidance talks about that if employers want to learn more about the EAU process, they can visit the website. I've linked to it here in the presentation. So if the slides are available, you'll be able to click on it, but you can also access it right from the EEOC guidance. And the reason this is important is that the FDA says in its EAU document that the FDA has to ensure individuals have the choice. They have to know that they have the choice whether or not to take the vaccine. So the question becomes, if an individual has the choice about whether or not to take the vaccine, does that preclude me as an employer from requiring it? Now, the guidance doesn't say one way or the other whether this EAU authorization means that employers can or cannot require vaccination. However, what we do know is that the EEOC guidance mentions the EAU process, but then it never says that it has any impact at all on whether or not an employer can mandate the vaccine. Also, that makes sense, presumably because an individual could choose and say, I'm not going to take the vaccine, but at the same time, an employer could say, you can't work unless you take the vaccine, in theory. So the fact that individuals have the right to choose does not necessarily mean that an employer can't mandate. The other thing that we're still waiting for, while this EEOC guidance was very good and it helped out and provided a lot of additional information, we still don't have any specific direction from New York State. And for those of you who are in New York State, which I assume is most of you, you know that all along, the governor has taken a very strong position on COVID policy. And in many cases, guidance from the CDC has been made unnecessary in New York due to the strict requirements that the governor put out. So we are still going to wait to see what, if anything, the governor or the state of New York through the Department of Health says about mandatory vaccination. Okay, so with that said, we can turn now to what does this EEOC guidance say? And Erin's going to start us off there. Next slide, please, Kathy.
Thanks, Adam. So we'll start with a very basic overview of some of the issues within the Americans with Disabilities Act, or the ADA, that may be implicated here. So generally, the ADA prohibits employers from conducting a medical exam or making a disability-related inquiry, except where it's job-related and consistent with business necessity. So how that comes into play here with the vaccination, the question is either administering the vaccine, or, as we'll talk about in a little bit, whether or not some of the pre-screening questions associated with the administration of the vaccine, whether or not any of those things implicate the prohibition on an employer to conduct a medical exam or engage in a disability-related inquiry, except where it's consistent with where it's job related and consistent with business necessity. So the EEOC first said that the mere administration of that vaccine is not a medical exam. What that means is, literally the needle going into your arm, that's not a medical exam. The EEOC said that an employer doesn't implicate or violate the medical exam prohibitions where the vaccine itself is being administered. But the issues arise where there may be pre-screening questions in order to get that vaccine. So for anyone who's taken the flu vaccine, you would know that when you go to get the vaccine, the healthcare professional who's administering the vaccine usually asks some very quick questions about allergies, or whether or not, if it's a woman, if they're pregnant, and there may be some other questions as well. So those pre-screening questions may implicate the disability-related inquiry aspect of the ADA, meaning that in order to ask those pre-screening questions that could elicit information about somebody's underlying medical conditions or a disability, those can only be asked where the questions are job-related and consistent with business necessity. That means that in order to, if you as the employer are mandating that the vaccine be taken at the person's place of work, or you've contracted with a third party to provide the vaccine to your employees, and you are requiring your employees to get the vaccine through you or through the vendor that you've chosen to administer the vaccine, to the extent that pre-screening questions are asked in that process, those questions have to be job-related and consistent with business necessity. Whether or not those questions are going to be job-related and consistent with business necessity is really a fact-specific inquiry. So generally, there has to be a reasonable belief that based on objective evidence, the employee who doesn't answer the questions and therefore doesn't get the vaccine through the employer would pose a direct threat to the health and safety of either that person or others. This can get into a lot. This is a really difficult analysis to apply, and especially here where the vaccine is so new. And it's going to implicate a number of factors. So for example, when you're doing this analysis, you'll have to think about whether or not, what is the person's job? Is that person exposed to a number of other employees, or are they relatively isolated? Can that person, are there accommodations that would allow that person to stay outside of the workplace? And Adam will talk about that a little bit later on. But this analysis as to whether or not you as the employer, if you are administering the vaccine yourself or through a third-party vendor, you really have to be careful about asking these pre-screening questions, because the EEOC has opined that they think that it would impact the disability-related inquiries prohibition under the ADA, and therefore you would have to show that doing this, that mandating the vaccine through you or through a third party is job-related and consistent with business necessity. There are a few exceptions to this. If you are offering the vaccine through your workplace, if the vaccine is voluntary through the workplace, then these issues are not implicated, because the employee has the choice whether or not to disclose that medical information to the employer. Additionally, if you are simply requiring proof of vaccination through an outside third party, such as a pharmacy, your own healthcare provider, that does not implicate the prohibitions under the ADA for disability-related inquiries or medical exams.
Erin, if I could jump in here for a second.
Sure.
I think this is important, and Erin's done a very nice job of summarizing it. The EEOC has basically given employers a little bit of an out, and has said, if you don't want to deal with the ADA and the job-related inconsistency with business necessity analysis, make the vaccine voluntary or only require proof that someone got the vaccine, rather than administering it yourself or having it administered through one of your contractors. So this is important. Now, this doesn't get rid of the accommodation analysis we're going to talk about later. But the EEOC is saying, if you don't want to deal with the ADA, here are some options.
Right. All right, next slide, Kathy. So the next slide, which I will talk very quickly about, is the impact on GINA. So GINA, which is the Genetic Information Non-Discrimination Act, prohibits employers from taking job-related actions based on an employee's genetic information. I won't go into detail on this, because generally the EEOC said, you don't really have to worry about GINA, because we don't think the administration of a vaccine is problematic under GINA. Getting the vaccine doesn't generally disclose the an employee's genetic information. However, the pre-screening questions, depending on how they are posed, may impact GINA. It really depends on what is contained within those pre-screening questions. The issue that the reason that this becomes somewhat of an issue is because if those pre-screening questions, and at this point, as I understand it, the pre-screening questions are not set, and they may change. It's a fluid situation. But to the extent those pre-screening questions ask anything about family history, and in particular, it could ask about family history of immune issues, autoimmune issues, that could implicate GINA, similar to the disability-related inquiries that I just talked about. So, and as Adam just very succinctly summarized, we can avoid all of those issues. Employers can avoid all of those issues, either under GINA or under the ADA, excuse me, as it relates to collecting information which perhaps we don't want or don't need to have. If you simply request proof of the vaccine rather than administering it yourself, you avoid any issue under GINA. And with that, Adam, I will turn it back over to you to talk about the accommodation issues that we've started to kind of give some insight to.
Thanks, Erin. So this is another point of clarification that the EEOC provided in its guidance. In our prior presentations, including the one that Erin was talking about from our Tuesday webinar, we talked about, in the context of the flu vaccine, we know that courts have said you can in theory have a flu vaccine requirement, so long as you have exemptions available for disability-related issues and religious, religious beliefs, I should say. So the EEOC has clarified that that is going to continue, and that is going to apply in the COVID vaccine context. So what does that mean? That means that if the way that the guidance says is that if the requirement, the vaccine requirement, screens out or tends to screen out an individual with a disability, the employer must show that the unvaccinated employee poses a direct threat to the workplace. And a direct threat is a significant risk of substantial harm to the health and safety of the individual or others that cannot be reduced by reasonable accommodation. So what the guidance says is you're going to have to perform this analysis with respect to someone who is requesting a disability exemption from the vaccine requirement if you choose to have one. So what does that direct threat analysis look like? Well, according to the guidance and case law, it requires you to ask several different questions, such as, what is the duration of the risk? What is the nature and severity of the potential harm? What is the likelihood that the potential harm will occur? And what is the imminence of that potential harm? The important thing here is that this direct threat analysis has to be performed on a case-by-case basis. It's not something that's going to be a one-size-fits-all analysis. You say, oh, well, we satisfied the direct threat analysis for this one employee, therefore it's going to work for everybody else. That's just not how the direct threat analysis works. You have to take it on a case-by-case basis.
Adam, I would also add to that it's typically a high standard.
Yes.
And not only is it case by case, but it is a high standard to meet. And how it will play out within this vaccination context and that we're in a pandemic, it's unclear, but typically it's a difficult burden for an employer to meet. So yes, this is out there and yes, this is an option, but we need to be wary that it is a difficult standard to meet.
Right. So if you have this employee who's requesting a disability accommodation to not take the vaccine, you have to go through this analysis. Now, even assuming that you are able to satisfy the direct threat analysis, you have to look at whether or not there is an accommodation that is available that would alleviate the potential issue. So for example, if you're an employee where remote work is possible, that's certainly an accommodation that you would need to provide to an employee who is raising a disability as a reason for not getting the vaccine. The guidance, interestingly, talks about exclusion from the workplace and distinguishes exclusion from the workplace from termination. And it is very clear that the EEOC is trying to say to employers, look, if you satisfy all this, you cannot accommodate somebody, there's no way that a reasonable accommodation is possible, you have to consider first excluding them from the workplace, and only as a last resort, termination or some other form of disciplinary action. Now, in the reasonable accommodation analysis, I should mention that you can't exclude from the workplace unless there's no way to provide a reasonable accommodation absent undue hardship. And undue hardship is a legal term that has been debated in courts across New York for many years, and not just in New York, excuse me, I should say across the country for many years. It is a very high standard. The EEOC talks about undue hardship as being significant difficulty or expense. And of course, you know, that doesn't mean anything, and it's going to be different from every one business to another. But know that it's a high bar. Undue hardship is a high bar and it's difficult to satisfy. So these are things that you have to consider. You have to have, if you're going to have a policy in place that mandates vaccination, you have to have an option for somebody to request an accommodation based upon disability. And then you have to proceed through this analysis to determine if you can provide a reasonable accommodation. Next slide, please, Kathy. The other potential accommodation issue that arises, according to the EEOC guidance, is sincerely held religious beliefs. And I'm not going to talk a ton about this because we've discussed this before, but the analysis is if an employee has a sincerely held religious belief that prevents them from obtaining the vaccination, then you as the employer have to provide an accommodation if one is available. And it's again the same analysis. Is there a reasonable accommodation available? And if not, is there an undue hardship? Or excuse me, is there a reasonable accommodation available that does not cause an undue hardship? Now, I would note that the standard for an undue hardship in the religious accommodation context is lower than the standard in the disability context, but it's still there. You still have to be able to show an undue hardship if an accommodation is available. Now, the guidance talks about, in this undue hardship analysis, looking at a couple of different things. One of them is you look at the prevalence in the workplace of other people who have gotten the vaccine. So if there are a lot of people who have received the vaccine in your workplace already, then the undue hardship might not be as much to provide them with accommodation. Similarly, you'd look at the amount of contact that that individual has with other employees when you're performing that an accommodation analysis, excuse me. Now, the guidance goes on to say that even if you have a disability or a sincerely held religious belief and there's no accommodation possible, it is lawful to exclude an employee from the workplace. But again, it talks about not terminating that employee. So the EEOC is telling employers be very, very careful about taking disciplinary action or terminating an employee because they did not receive the vaccine. And with that, I will turn it back to Erin. Next slide, please. Thank you.
All right, to sum up and kind of conclude our presentation here, we've provided a few, what we see as really the 4 options that employers have. Now, this is all to say that I think we all are aware that the vaccine is not generally available at this point. So for most employers, this is looking ahead probably to second, if not third quarter of next year, when it seems more likely that the vaccine will be generally available to the population. At this point, we are vaccinating only the most high-risk individuals as well as healthcare providers. But once we move into next year and the vaccine becomes more widely available, you will want to think about how you want to handle vaccines within your own organization. So the first option would be no action. You know, there's no requirement that you want your employees to be vaccinated. You're letting employees make their own choice about the vaccine, and you handle the health and safety concerns posed by COVID as we have over the course of the past several months based on whatever state or federal mandates there might be for PPE, social distancing, all of the things that we've come to live with over the course of the past 9 months. Another option would be to encourage employees or incentivize them in some way to voluntarily get the vaccine. We could do that on site, as we discussed, but have it be voluntary as opposed to mandatory. But you could try and encourage your employees to get the vaccine without mandating it, and providing opportunities for employees to more easily access that vaccine to the extent that you can. A third option would be to mandate proof of vaccine, again, assuming that we can mandate employees to get vaccinated. One way to meet this would be, as opposed to having the vaccine required on your premises or through a vendor of yours, an employer could mandate proof of the vaccine, that the employee got the vaccine. And then lastly, you could mandate a vaccine that is administered by the employer or a vendor contracted by the employer. Again, if you do this, if it's 1, permitted, and 2, if you do decide to do that, keep in mind the issues that we just talked about in connection with the ADA and with GINA. All right, next slide, Kathy. A few tips to the extent you do decide to implement a mandatory vaccine policy. Some things to keep in mind. You'll want to ensure that there's a legitimate basis to mandate that vaccine, that there is a health and safety reason to mandate employees getting the vaccine. You'll want to think about your own organization, the industry that you're in, and decide whether or not there is a legitimate basis to mandate the vaccine. You have to allow for exemptions within your policy, exemptions for medical conditions, which would include certainly pregnancy-related issues, and exemptions for sincerely held religious beliefs. You'll want to have a clear process within that policy for an employee to request an exemption. Any exemption that is requested, you want to make sure that you do a case-by-case review, and you'll want to streamline that process so that you really have a few individuals who are in charge of reviewing those exemptions and making the decisions on them. You'll want to make sure that you very carefully review those requests. You may want to seek help and advice of outside counsel, given the newness of this vaccine and the various issues that may be implicated here. Be sure to document everything you do, especially if you do provide a reasonable accommodation, as Adam was talking about. Make sure you document that. If you decide that you cannot provide a reasonable accommodation because it would pose an undue hardship, be sure to document why you believe that there is an undue hardship. You'll want to provide training for your supervisors and managers and anyone who may receive a request for an exemption from the vaccine mandate. We are only as strong as our weakest link, so make sure that your supervisors and managers are trained to recognize where somebody might be asking for an accommodation or exemption from the policy. And then lastly, where you do have employees who refuse to get vaccinated, please make sure you understand why before you take any disciplinary action. You really want to make sure that there's not a medical or religious reason, because if there is and you take disciplinary action, we might run afoul of the Title VII or the ADA. And with that, we conclude our presentation. I did not see any questions pop up through the chat, but if you do have any questions, you can submit them after the presentation. And we thank you all for attending and hope you have a nice weekend.